find it. And there's the nice Zoom lady. So I want to make a brief introduction to Dale, who's a member of our Law Society, as well as member of the Saskatchewan Bar and the Nunavut Bar. Dale's had a legal career that spanned 4 decades. He graduated from the University of Saskatchewan with a Bachelor of Law degree in 1980 and was called to the bar of Saskatchewan in 1981. He was in private practice with several firms from 1981 to 1995. And in August 1995, he joined the Federal Department of Justice in Saskatoon. He has at times been the regional director of the Saskatoon office. And I first encountered Dale when he took an assignment to the northern region in Yellowknife in 2018. And Dale was later in Iqaluit as well for 5 months in 1920. Dale's back in the Saskatoon office now, although I think he's still working from home. And Dale is the longest serving lawyer in the Department of Justice Saskatoon office. Dale is also a curler of some renown. Those of you that curl will understand when I say that he represented Saskatchewan at the 2017 Canadian Masters Curling Championship, and during his brief time in Nunavut, he represented Nunavut at the 2020 Brier. Dale is quite a curler. All right, Dale, I'm going to turn things over to you without anything further.
Thank you. I'm broadcasting from my home office in the suburban neighborhood of Saskatoon. And I'd like to point out that the presentation I'm giving today is based on my views and are not necessarily the positions or opinions of the Department of Justice Canada. I anticipate that this presentation will take about 1 hour and 15 minutes. Next slide, Glenn. So the table of contents outlines the topics I intend to cover here in the order in which they're presented. And hopefully we'll have some time at the end for you to ask some questions, but as Glenn also invited, you can put some through during the presentation as well. Next slide. So a little bit of the common law history of the doctrine of frustration. The first prominent case was from the English Court of King's Bench in 1647. It was a case in which a landlord sued a tenant for non-payment of the rent of leased lands. And the defendant had objected to payment because he had been ejected from the lands by an enemy force, arguing that he was denied the use and benefit of the leased lands by an event or a third party beyond his control, and therefore he should be exempted from having to pay the rent. However, the court ruled in favor of the landlord because it found that there was no exemption for the tenant for payment of rent in the lease document. So it ruled that a party whose performance was rendered impossible could have provided for that contingency in the contract, but failing to do so, it had to perform or was liable to be found in breach. And I point out that in this case, the leased lands still existed. And so the question really is, was it impossible or just impractical for the tenant to have regained the use and benefit of them by retaining a superior force against that enemy? This is an issue that plays out throughout many of the frustration cases that we'll be reviewing. Next slide. So that decision in 1647 endured in England for over 200 years. It changed in about 1860s when contracts were found to have an implied condition of impossibility. In the Taylor and Caldwell case, the English Court of Queen's Bench, Taylor sued Caldwell for the breach of a contract due to Caldwell's failure to provide the use of a music hall that he had rented and intended to use for concert performances that he was going to provide on 4 dates. Unfortunately, before the first concert was held, the music hall was destroyed by fire. And Taylor, who wanted to run the concerts there, sought damages for the wasted costs that he had incurred in preparing for the concerts and for the lost revenue because the concerts were no longer going to be held. The contract did not provide for consequences if the music hall was destroyed, but the court ruled that it was subject to an implied condition that both parties would be discharged if the hall ceased to exist through no fault of their own. And so the principle is that the destruction of the subject matter of the contract without fault of the parties that renders it impossible to perform relieves both parties of their legal obligations to perform. Next slide. Well, it only took about another 40 years before the courts decided to evolve that principle a little bit further. In 1903, the English Court of King's Bench had a case in which a defendant rented 2 rooms from the plaintiff for a specific period of time and paid a deposit in advance. Now, both of the parties to this contract understood that the defendant's purpose in renting these rooms was to watch the coronation parade of Edward VII that was scheduled to take place on the street below where these rooms were located. The contract actually failed to specify this intended purpose or to provide for the cancellation of this royal parade. It turned out that Edward VII fell ill prior to the scheduled coronation, so it was postponed, and so was the parade that was scheduled to take place on the room below these rents. As a result, the defendant refused to take the rooms and refused to pay the remainder of the rents, and that caused the plaintiff to sue for breach. In this case, the court ruled for the defendant, the tenant or renter, because although the performance of the contract was not physically impossible, it had become impossible for the intended purpose, inasmuch as, to quote the court, the state of things going to the root of the contract and essential to its performance had ceased to exist. Next slide. This doctrine of frustration carried on and was eventually summarized in a number of decisions from high-level courts in England and elsewhere in the Commonwealth. One of the most famous is the Davis Contractors case from the English House of Lords in 1956, where one of the lords wrote this summary of the doctrine. Frustration occurs whenever the law recognizes that without the fault of either party, a contractual obligation has become incapable of being performed because circumstances in which the performance is called for would render it a thing radically different from that which was undertaken by the contract. And his lordship refers to a Latin phrase which translated means, "It was not this that I promised to do." That summary of the principle was accepted and adopted by the Supreme Court of Canada in 2001, and Mr. Justice Binney summarized it as, frustration occurs when a situation has arisen for which the parties made no provision in the contract, and the performance of the contract becomes a thing radically different from that which was undertaken by it. So there's a period of about 50, 60 years between those two decisions. Next slide, Glenn. But in that intervening period, the House of Lords actually attempted to refine its definition or summary of the doctrine. And I've inserted here a much longer, but still only one sentence long summary of the doctrine of frustration. I won't read it all, but I've highlighted what I think is the key passage in it, and that is the intervening party must be something that is so significantly changes the nature, not merely the expense or the onerousness of the outstanding contractual rights or obligations. This was a case in which I think it was a trucking company or carrier had leased a warehouse from the owner for use in its transport business. During the term of that lease, a local municipality issued a bylaw that directed that the road access to the leased warehouse be closed. I think it had something to do with some road repairs that were being made at the time. And the denial, or this road closure, denied the tenant of 20 months usage over the 10-year term of the lease. And so it argued that it should not be required to pay lease rents during that period. But the court, however, ruled that that loss of use for 20 months was not serious enough to fall within the doctrine of frustration. And so the tenant was not released from the obligation to pay rent during that period. So it's interesting that a 20-month period out of a 120-month term is not sufficient enough to bring in the doctrine of frustration. Next slide. This summary was also accepted in Canada, primarily in the KBK number 138 Ventures case out of the BC Court of Appeal in 2000. This was a case in which a commercial property developer had purchased land at a price of $8.8 million for the purpose of redeveloping it for future commercial use. And after purchasing this land, the local municipality rezoned it into a different category. And that rezoning then restricted the future development of the land as the purchaser developer had intended, and ultimately reduced its market value to $5.4 million, thereby causing a capital loss to the developer of $3.4 million. And the court ruled that this did constitute a frustration of contract. It quoted a decision from a BC Supreme Court, and I'm not going to read all of the quote that's there, but again, I've highlighted what I think are the key principles to be drawn. And the court accepted that the disruption must be permanent, not temporary or transient. The change must totally affect the nature, meaning, purpose, effect, and consequences of the contract so far as concerns either or both parties. So you can see that even though the property could have been used for a commercial redevelopment, because it wasn't going to produce the economic returns that the developer had initially contemplated, the court felt that was sufficient to invoke and accept the principle of frustration. Next slide. I've inserted this case into my presentation. It's from the New South Wales Court of Appeal in Australia. It's a case in which the property owners contracted for a residential renovation work to be done by or under the supervision of an experienced contractor in that trade. And the contract called for it to be completed within 20 weeks from the commencement of the renovation work. The work did commence, but the contractor then suffered a brain injury and he fell into a coma for a period of 5 weeks. Ultimately, he was unable to return to work for about 5 months. So the contracted work was not completed within this specified time period. The owners therefore sued the contractor for breach of contract. This case went to a commercial arbitrator and then to a lower court before it finally got to the New South Wales Court of Appeal in 2004. And that court applied the Davis Contractors principles and ruled that the contract was indeed frustrated, but only at the point of 2 weeks into the period of the contractor's coma. That is, after part performance. It's interesting that the court felt that it was appropriate to wait a 2-week period of time to find, I guess, to wait and see if the contractor's coma would indeed end shortly or extend beyond that initial 2-week period of time. In coming to its decision, this Court of Appeal overturned the ruling below that it held a temporary injury is not sufficient to frustrate a contract. But the court did not challenge the statement that the doctrine of frustration is not to be lightly invoked. Next slide. This is a case out of the Hong Kong District Court in 2003 that deals with an epidemic, not a pandemic. It was a case in which severe acute respiratory syndrome, or SARS, had begun to take effect in Hong Kong. And as a result of SARS, the tenant of a 2-year lease of a residential property became subject to a public health authority isolation order related to SARS that imposed a 7-day period of isolation that somehow impacted his ability to make use of his apartment. The court ruled that that short period of isolation was insignificant in comparison to the 2-year term of the lease. Now, I did find another case, which unfortunately, I guess for us, didn't actually make its way to court, but in August of 2014, European multinational commercial and industrial developer announced that it was suspending its planned expansion of an iron ore mine in Liberia because of the Ebola epidemic in West Africa that was then taking place. And it relied on a force majeure clause or provision. I don't actually know what the provision was, and I'm not even sure if it was ever challenged by anyone, but it does indicate that there are instances in which epidemics are used in a force majeure context. I found that there's a rather dearth of case law on whether a pandemic justifies the frustration of a contract. Next call. So just to summarize, where frustration applies, both of the parties are fully discharged from performance of the contracted obligations, even if it's after part performance of that contract. The implied condition concept for frustration that used to be relied on by the courts has largely been abandoned by them. But one should question, I think, why should not one of the parties be required to insist that it be an express condition if in fact it's so important to one of the parties? For an example, is renting a room to watch an event that's scheduled to take place on the street below so radically different in nature from renting a room with merely a view to the street below? What if the event that one of the contracting parties intends to make use of that room is not actually canceled, but is simply moved 1 block away, such that the occupant of the rooms could still see the event, the coronation parade, for example, even if he might have to stick his or her head out of the window and use binoculars to see that event. And using some of the language reflected in the court's decisions, does incapable of being performed or radically different reflect impossibility, mere impracticability, the loss of the essential purpose of the contract for one of the parties, either with or without their knowledge? Or is it one party's loss of the economic feasibility or prospects of the contract? How substantial must that loss be? and how permanent or long-lasting. Next slide. So this takes me into a consideration of force majeure clauses. In these bullets, I point out that there are clearly some uncertainties surrounding when the doctrine of frustration applies. It's clear that its application is limited to only those cases where unforeseen circumstances have arisen for which the parties made no provision in the contract, so that the performance of the contract becomes impossible, or, to quote, a thing radically different from that which was undertaken. I point out that the sole consequence of frustration is that it fully discharges both parties from their obligations from the time that the frustrating event intervenes. And as a result, these matters motivate contracting parties to incorporate force majeure clauses into their contracts so as to increase the certainty in the contracts and to provide more flexibility than would otherwise be allowed at common law. Next slide. I want to point out that force majeure is not a freestanding principle under the common law. It requires that the parties to a contract include specific provisions for it. The parties are, of course, free to draft their force majeure clauses as they see fit, but I found an Alberta Court of Appeal case in Atcor from 1996 in which the court states that force majeure clauses should cover at least three topics or items. Firstly, how broad should the definition of the triggering events be? Second, what impact must those events have on the party who invokes or purports to invoke the force majeure clause? And thirdly, what effect should invocation of the clause have on the contractual obligations in that contract? So in the next few slides, I'm going to consider each of these topics individually. Next slide. The force majeure clause should list some specific events that are tailored to the parties, to the contract subject matter, and reflect known or foreseeable potential intervening events and circumstances. It should also include a generic basket clause, and it should refer to events that are beyond the control and influence of the parties. And I suggest it should also specify the minimum duration of the impact of that event upon the performance of the contract by one or more of the parties. So to give some examples of what typically we find in force majeure clauses, there are things like severe weather and geological events, like a hurricane or an earthquake, fires, acts of civil, police, or military authorities, war, terrorism, major crimes, and other disturbances, such as labor strikes and lockouts, blockades of roads, destruction of production facilities, and even things like loss of third-party supply, transportation by third parties, loss of power or other key services, and death or loss of key personnel essential to the performance of the contract. And there are even cases of adverse impacts of court or public authority orders, supervening illegality, and epidemics or pandemics. Next slide. I also want to talk a little bit about the acts of God force majeure provision. There is little jurisprudence about what constitutes an act of God, and I would submit that given how science has advanced our understanding of the forces of nature and the workings of our world and of the universe, there may be few events now that could truly be attributed to acts of God. However, in 1975, the Supreme Court of Canada did attempt to define what it understood to be an act of God in the Atlantic paper stock case that I've cited there. And it was described by the court as a supervening, sometimes supernatural event beyond the control of either party, which makes performance impossible. The common thread amongst interpretations of acts of God in the decisions is that they be unexpected and also beyond the reasonable human foresight and skill. I would suggest to you that not much reliance should be placed today on a force majeure clause that simply refers to an act of God. Next slide. Force majeure clauses should describe triggering events that are radical as to strike at the root of the contract. Now, in interpreting force majeure clauses, courts will consider the jus dem generis principle, which is the principle that broad general clauses that follow specific clauses will be interpreted in a manner that is consistent with the previous specific clauses. And that principle can be found in the Atlantic paper decision that I cited earlier in this presentation. So a basket clause should be worded to overcome this principle. And perhaps I should give an example of what I mean. If the specific force majeure events are described as things that occur in nature, that is naturally, such as weather events, geological events, things of that nature, then a basket clause that will only, or the courts will interpret a basket clause to mean it refers to other intervening events that occur in nature and would not be intended to apply to man-made events. So a force majeure clause that talks about natural events probably will not be reliable to exclude or discharge, or sorry, to invoke the force majeure clause where it's a man-made event, such as a labor strike or lockdown, a change to a bylaw that renders an activity improper, a road closure by municipal order, that sort of thing. So at the bottom of this slide, I asked the question, should the contract also provide what particular events are not force majeure events? And for example, I mean events that do not impair performance of the contract by either less than a specific period of time or reduce the value of the expected benefit of the contract by less than a specific percentage. Next slide. In considering a potential force majeure event, the unexpected nature that is beyond the control of the parties and its particular effect on the abilities of the parties to perform their contract are usually considered to be quite important factors by the courts. However, I've seen a couple of cases in which the courts may decide to read in the unforeseeable and the beyond control of either party aspects in force majeure clauses, even if they are not expressly set out in those clauses. And again, I provide a cite in the Atlantic paper case where that can be found. But I give another example in this 1983 BC Supreme Court decision in West Fraser Mills and Crown Zellerbeck, where the court applied a force majeure clause even though the event had actually been foreseen by the parties, although it was still beyond their control to prevent it from happening. So courts will sometimes read more into force majeure clauses than is actually expressly contained in them, but good drafters should not want to rely on the court's discretion to do so. Next slide. As a general rule, courts tend to limit the application of the force majeure clauses to the events that beset the contracting parties only. That is, if the intervening event affects party A or party B to the contract, then it's more likely to invoke the force majeure clause. But if it's an event that impacts a third party, and that party's response or reaction is that it's going to have an adverse impact on the contracting parties, the courts are less likely to accept that as a force majeure event. So to overcome that, where a party wishes to invoke a force majeure clause to protect itself against adverse actions or omissions by third parties, then the best practice is to draft the force majeure clauses that provide that protection. So to give an example, it might be a case where there are non-performing suppliers, financiers, or customers of the parties to the contract that then adversely impacts the contracting party's ability to perform. I give a couple of examples on this slide. In TransCanada Pipelines and Northern and Central Gas Corp, there's a situation in which Northern and Central Gas purchased its gas supplies from TransCanada and then sold those purchased gas supplies to a number of fairly major customers. When some of those customers suffered strikes at their facilities, they shut down their operations. This meant they didn't have as much demand for the gas supplies from Northern and Central Gas, and this then meant that Northern and Central Gas didn't need to purchase as much gas from TransCanada. It then sought to reduce its obligation to perform or to purchase a specified minimum amount of gas from TransCanada because of those problems suffered by its customers. The court in Ontario did not accept that as a justification for reduction of Northern and Central Gas's obligation to buy and pay for a minimum quantity of gas from TransCanada. But it can turn out differently, and the Tenneco Canada and BC Hydro and Power Authority case from 1999 in BC provides a different outcome. And there, the BC Court of Appeal accepted that the strikes being suffered by the customers of BC Hydro and Power did justify the invoking of the force majeure clause. And that was because of the particular wording of the clause in the contract with TransCanada, and because the court decided that the effect on the customer of BC Hydro is exactly the same as if its own workforce had been on strike. So again, courts come to different conclusions based on the circumstances and on the particular wording of the force majeure clause. Next slide. What seems to be a common thread amongst the courts is that a party who seeks to rely on a force majeure clause must bring itself squarely within it. And I cite two cases there, one from Nova Scotia and one from the English Court of Appeal. And so oftentimes the force majeure clause will set out that the party who seeks to invoke it must give a written notice of its intention to invoke the clause, must provide the notice within a certain period of time, and must give some sort of description of the intervening or supervening event and its consequences on the contracting party, and why that justifies the application of the force majeure clause. I think I have another case later on, which gives a specific example of this point. But I'd like to move on to the next slide. So here I want to take a look at some of the impacts that may or may not result in a valid invocation of the force majeure clause. The clause should clearly set out what the impact is that is required in order for it to be relied upon by the invoking parties. And the Supreme Court of Canada commented in the Atlantic Paper decision that these clauses generally operate when a supervening event makes performance impossible. Well, as we'll see, it's not just making performance impossible that these clauses can and should cover. In the Atcor case from the Alberta Court of Appeal, which I mentioned earlier in my presentation, the court stated that a supplier need not show that the event made it impossible to carry out the contract, but it must show that the event created, in commercial terms, a real and substantial problem, one that makes performance commercially unfeasible. So you'll see that there's quite a bit of difference between these, the wordings in these two cases, one from impossible to another one to make it commercially unfeasible. It's clear, however, that the force majeure event must be the cause of the performance problem. So when the event creates a situation where a party can perform only a limited number of multiple contracts that are impacted, it must act reasonably in determining which contracts and to what extent it will endeavor to satisfy its conflicting contract obligations. And the force majeure clauses should contemplate this. So to give you an example of what I mean by this bullet, let's say you have a client who is a major supplier of products to 5 major customers. As a result of some force majeure event, it is no longer able to supply 100% of its contracted supplies to all 5 of its customers, but it can supply 60% of its normal production to its various customers. So in that situation, does the client choose to supply 100% of its product, but to only 60% of its customers? Or does it choose to supply 60% of its product to 100% of its customers? Whatever it may choose, the force majeure clause that it has in each and all of its contracts with its customers should indicate what its choice is and ensure that its selection of options is consistent between and amongst all of its contracts with its customers. In other words, we want to avoid a situation in which, in some cases, the client is to supply 100% of its contracted production supply to some of its customers, but only 60% to others, because ultimately it will not have enough supply to deliver to all of its customers under those conflicting provisions. Next slide. The party seeking to invoke the force majeure clause must give the notice of its intention to do so in accordance with the terms of the contract. And here I give another example from the Alberta Court of Queen's bench about that. The notice may, or perhaps is required, to include a description of the event being relied upon to invoke it. That gives the other party to the contract a chance to assess whether indeed the provision is being properly invoked. Now, I set out that contracting parties are able to set out the various effects of the force majeure event on their respective contract obligations. And I list what I think are the 4 most common ones, but I wouldn't want to suggest that these are the only ones that might be considered. But the 4 I've listed are that the supervening or force majeure event may result in the termination of the contract, either immediately upon the supervening event or after a specific period of time after the event occurs. Secondly, it may call for the temporary suspension of obligations under the contract or an extension of the contract performance deadlines. Thirdly, it may provide for an amendment as set out in the particular force majeure clause that allows partial performance with a discharge of some obligations that have then become impossible or commercially unfeasible. And the last one that I contemplate is that it could provide for an allocation of financial burden between the parties. So to elaborate on that last one, let's say the 2 contracting parties discover that a force majeure event is going to result in either added costs and or loss of income or some other damages to the tune of $2 million in total between them. The force majeure clause may set out that the allegation or the allocation of that financial loss is to be borne 75% by party A, but only 25% by party B. And then the parties simply need to hire some good accountants to accumulate account for all of the losses that they want to throw into this pool that's then to be shared between them. Next slide. In this slide, I want to point out that contracting parties are not able to use force majeure clauses to impose provisions that are not yet present in the contract. And in this Tepstra management case, I set out how that came to be a principle that's recognized by the courts. As I recall, Terpstra was a timber supply company in Newfoundland that had contracted to supply timber products to a European company whose name I won't attempt to pronounce here. What happened was that winter in Newfoundland extended beyond the usual period of time. The weather did not permit Terpstra to commence harvesting its timber products in the time frame that it had contemplated in order to fulfill its contract. And so it was late in commencing the delivery, and it invoked the force majeure clause to permit the late delivery of its product, and also to extend the final deadline date by which it could deliver its product. And the court ruled that the supplier was not able to rely upon this clause to permit the late delivery because the contract did not itself provide for that to be done. In the next bullet, I point out that parties may also provide for multiple contract consequential options that depend upon the severity and or the duration of the force majeure event. So for example, there might be one particular consequence if the force majeure event is rather severe and quite long lasting. There might be a different contractual amendment or effect if the force majeure clause is of immediate moderate severity or moderate length, and an even third different option for consequences if the force majeure event is of minor severity and of not long duration. I'd like to point out that another possible option would be to specify a default force majeure consequence. That is, in the event of a force majeure event, this is what shall happen, and these are how the contractual obligations will be amended. But the clause also goes on to provide that the parties to the contract will have an option of attempting to negotiate within, say, the next 14 days or 30 days, an alternative consequence if they are able to reach one. And if they are, then the alternate consequence is to take effect and the default consequence no longer applies. Next slide. Well, I'd like to talk a little bit about the duty to mitigate under force majeure clauses. So events and consequences that are beyond the control of the contracting parties suggest that there is a legal obligation to take steps that are actually within their control. And that, I think, indicates that there is some obligation to mitigate against the adverse impacts, even if the event itself could not be prevented or overcome. And I've cited here the frozen rabbits case from the English Queen's Bench Commercial Court in 1975. This was a case in which the supplier had contracted to supply frozen rabbits to, I'm thinking it was a pet food supplier at the time, but I'm not positive of this right now. Anyways, the supplier got its frozen rabbits from a supplier in China. And for some reason, that supplier was unable to provide its frozen rabbits to the this supplier, Tucker and Cross. And the court ruled that the defendants were unable to invoke the force majeure clause in this situation because they failed to show that they were unable to buy Chinese frozen rabbits from some other supplier other than the one with whom they had their initial contract. And so unless they could show that they couldn't get Chinese frozen rabbits from some other supplier, they are unable to show that they were prevented from fulfilling their contract by a cause that was beyond their control. And I have another one that I'll raise later on in this presentation. The next slide. And this is it. So in this case, AMCI Export attempted to invoke a force majeure clause in its contract to supply coal to Nova Scotia Power Company because the supplier, was unable to access coal from a particular single region in South America where it had contracted to obtain its coal supply. And that was because a rock slide blocked the main road to that region's coal source. So the contract obliged AMCI to provide South American coal to Nova Scotia Power, but the court ruled that simply because it couldn't get its coal from the one particular source that it had relied upon, it could and should have looked to other sources of South American coal to obtain its coal sources for then sale and delivery to Nova Scotia Power Company. So force majeure clauses may also set out what particular mitigation efforts, if any, must be undertaken by the parties, such as efforts to temporarily secure products and or services from third parties that are not impacted by the force majeure event. And similarly, I think the clauses could also specify what mitigation measures will not be required, so that a contracting party is not expected to go to what it would perceive to be extreme events in order to mitigate its failure to perform. Next slide. Okay. So the next few slides, I talk about the interplay between force majeure clauses and the doctrine of frustration. Force majeure clause events can include those that would not otherwise qualify as frustration events. And I cite the M.A. Hanna case that I referred to above from the Nova Scotia Supreme Court that ruled that there is no frustration merely because performance of the contract would be commercially unprofitable, at least where performance is still physically and legally possible. But the court then concluded that Sydney Steel, in that case, had brought itself within the force majeure clause. So in other words, the court held that the doctrine of frustration would not have applied, but the provisions of the force majeure clause in the contract between the parties did apply, and because it did apply, it released the supplier from some of its obligations for performance in that contract. And conversely, contracts that do contain force majeure clauses can still be discharged by frustration because the supervening event was not actually contemplated in those force majeure clauses. So I cite two cases there. And in the Petrogras Processing Limited case, as I recall, it was a contract for the supply of natural gas to a customer. I think it was a situation in which the government of Alberta passed a regulation that dictated a minimum price at which gas supplied from Alberta oil fields could be sold and supplied to customers outside of the province. And the contract came to violate that new regulation by the Alberta government. And so that supervening event that caused the illegality in the contract then served to discharge the supplier from the delivery of that gas. In the second case, involving the BC Minister of Crown Lands and a development company, that was a case in which the development company had purchased some lands from the provincial crown with the intention of some commercial/recreational development project, but it required a rezoning of those lands for its project by a certain date. And unfortunately, the provincial minister delayed the rezoning of those lands, and so the project could not be started at the time contemplated by the contract. And that then allowed the developer to invoke the force majeure clause and get out of its contract with the provincial crown. Next slide. The Fishman and Wilderness Ridge case is another example of force majeure clauses and frustration coming to play in the same circumstance. So in this case, the Fishmans had contracted for the purchase of a condo unit that was to be constructed by Wilderness Ridge and delivered to the Fishmans by February of 2010. Unfortunately, during the construction period and prior to the delivery date, the condo was destroyed by, or partially built condo was destroyed by fire. The Fishmans apparently decided they didn't want a condo in that location anymore, and they claimed frustration in order to be discharged from their performance to buy and pay for the condo that was being built. But Wilderness Ridge invoked the force majeure clause that was in a contract, and it had permitted a delay in performance for events beyond its reasonable control. And in this decision, the Alberta Court of Appeal considered the Krell and Henry case and the Taylor and Caldwell cases, which are on the first 2 or 3 slides of my presentation dating back to 1903 and 1863. And the court ruled that combined with the force majeure clause in this contract and the fact that the condominium can be rebuilt exactly as promised, although with a 1-year delay in delivery, in this case, the destruction of the condominium by fire did not amount to frustration. Next slide. This slide I just put in to let you know that there are similar provisions in the Civil Code of Quebec. I'm not going to deal with them, but if we jump to the next slide, I'll give a very recent case in which the pandemic actually did come to be applied in a contract between 2 parties. One party operated a fitness center as a tenant in a property owned by the landlord, but it was denied its use of the fitness center for a period of 3 months because gyms were not designated as an essential service under Quebec's pandemic shutdown or lockdown order in council. So the tenant sought relief from paying rent to its landlord for that 3-month period. The landlord, however, argued that the tenant was not in a force majeure event. It pointed out that there was a lease provision that still obliged it to pay rent in any such event, and that there was an emergency government loan from Quebec of $40,000 that prevented the tenant from claiming that it was rendered incapable of paying the rent. In other words, the landlord said you can get a provincial government loan to take the place of the revenue that you would have earned but have now lost from your inability to operate your fitness center. The court dismissed the tenant's contention that it was prevented from paying rent. But in a somewhat interesting twist, the court then went on to rule that the provincial order in council prevented the landlord from honoring its obligation to give possession and peaceable enjoyment of the premises to the tenant, and that there was another article in the code that then prevented it from collecting rent from its landlord. Next slide. And so I come to the conclusion with these 4 bullets. And that is that the doctrine of frustration and contractual force majeure clauses are related under common law, and both may need to be considered and analyzed in any particular case. The frustration doctrine relieves contracting parties of their legal obligations, but it may lack certainty under the law and may not produce a desired result for one or perhaps even both of the contracting parties. Force majeure clauses, on the other hand, can increase certainty. They may serve to preclude frustration in some situations, and they can provide greater flexibility in producing more desirable outcomes for one or even both of the contracting parties. And I suggest in closing that well-drafted force majeure clauses will clearly set out what the triggering events will be, what the adverse impacts that they must have on the performance of the contracts, and then will prescribe how the contractual obligations of the parties will either be altered or may be revised by them. So I hope all of you will find this presentation to be helpful at some time in the future. And I'm open to answering a few questions if you have any.
Thanks very much, Dale. Questions, anybody? And again, if you could put them in the chat, I'll be able to pass them on to Dale. Dale, you would not, I believe, be opposed to us putting your slide presentation up in the YouTube channel along with the video?
I would not.
Great. So that'll be up as well when we get the video up later this afternoon. Last call for questions. All right, there doesn't appear to be any, Dale. So again, thank you very much. And thank all of you for attending. Oh, wait now. Here we go. Oh, these are all thank yous, Dale. So thank you again.
I'm glad for that. And perhaps I should add one thing. I'd like to apologize to those people who expected me to give this presentation in November. It was entirely my fault that did not go ahead as planned, and I'm sorry for the inconvenience that caused to you who were expecting it.
Not a problem. All right. Thank you, everybody. Thank you again, Dale. Everyone, enjoy your weekend. And that's it. Thank you.
Bye now.